Welcome to the roundtable for modules 4 and 5 liquidations. We're going to put them together. Today I'm joined by Jeanette Muller, a registered liquidator, Claire Burney again another registered liquidator, and John Shanahan. He's a registered liquidator but also a trustee in bankruptcy. So we're going to talk about liquidations and we're going to have a general discussion. I want to bring out the practicalities of liquidations. This obviously is a lot of work for a insolvency practitioner, and a lot of the work will be around liquidations. I just want to have a look at behind the scenes to some extent as to what has to happen and the logistics of that. First, we're going to touch on provisional liquidations. Now, provisional liquidations, as you would have picked up during the Module 4, is basically where there is a need to protect the assets. So, John, provisional liquidation is probably not a regular occurrence, but on what scenario would you see a provisional liquidation being relevant?
Effectively, a stakeholder, normally a director, is mucking up, not providing information to the other directors. Assets are in jeopardy, which it being the major application to court, advising that the assets are in jeopardy and that an immediate appointment is required to protect those assets and the dissipation of those assets.
Would that be used by a secured creditor as well in that scenario? No, because they could go straight to or they could exercise their rights under the receivership, I suppose.
Correct, yeah. Correct.
All right, so in that case, it's it doesn't happen often, shall we say?
It doesn't happen often. And then what's necessary is that an application is made for the winding up of the company, for which the provisional liquidator provides a report to the court on the situation of the company. It may well be that the company's not insolvent.
Yes.
However, that the assets were protected as at that time the provisional liquidator was appointed.
Right. Okay. Ladies, any comment on that?
No, just that with respect to a provisional liquidation, it's important to remember that when you're thinking about your fees, how do you get your fees approved for the provisional liquidation? You can't ask creditors. You have to go and do a fee application to get those fees approved.
To the court.
So it has to go to the court. It's not that common, provisional liquidations.
Yeah. Just going on from that, with respect to a liquidation, we have a scenario where all the ducks are in a row, as it were. You're approached by a relevant creditor, maybe who's issued a statutory demand and the demand hasn't been met. So what do you look at with respect to a company as to whether to accept the appointment as liquidator?
To provide a consent for an application for winding up.
Practically speaking.
Don't necessarily do too much.
Yep.
You're sort of relying on the lawyer that's making the application to the court for the winding up as to, they would normally say, we believe this to be the case, we believe they've got these assets. This is where we believe our creditor is going to get paid from. Yep. And therefore that would suggest that there'll be funds available to pay us.
Janet, any comment on that?
Look, John's absolutely right. I suppose the most active creditor who does most winding ups in Australia would be the Deputy Commissioner of Taxation.
Yeah.
So,
he's got a bit of power.
Yes, and they have a panel. So a lot of different liquidators lodge consents. And when you're getting a consent from the tax office, there's not a lot you can check. It's just the Commissioner's asked you to consent to be a liquidator in a winding up, in goes your consent. And it's pretty much like a lucky dip, I suppose you'd say, and you just see what you get at the end of the day.
And you stay on that panel because you take the good with the bad.
Yeah.
It's normally more bad than good.
Claire, on a statutory demand basis, winding up, do you rely on the lawyers to tell you that you've got a valid statutory demand and it's all okay? Because the courts are fairly strong on the I's are dotted and the T's are crossed in statutory demands, aren't they?
In providing a consent for So we usually receive a copy of the demand so that we can understand the nature of the debt. It's not our job necessarily to determine whether the statutory demand is relevant or not. That's part of the application that's made.
Sure.
We're providing a consent on the basis of we have no conflicts and we have the capacity to undertake the appointment.
So on capacity, that's an interesting point. So obviously capacity with respect to resources becomes very important depending on the size of liquidation.
Yeah. So when you get a consent for a court liquidation, it's prudent to, see what you can find publicly about that company. Obviously, if it's a well-known name, you're going to know that if you're a small firm, it's maybe something that you don't have the capacity to undertake and consent to. So there's a limited amount of inquiries that you can do to determine whether you have capacity. But should you get appointed, there's always the opportunity that if your capacity, the scope of the job falls outside your capacity, there are options available to you.
Sure. And going on, I know I teach, when I teach insolvency and when I teach the Personal Property Securities Act, I always tell my students that when liquidators walk in, one of the first things they'll do is go and search the PPSR to see what assets are around. Is that true or not?
The PPSR is very important to determine what security interests are out there and who may have a claim over certain assets. It's also pertinent when you're looking at employee entitlements
Sure.
to know who has or who may hold a ORPAP security interest.
Yep. Just moving on to members voluntary. Oh no, before we go there, actually, one thing I'd really like to know is basically the logistics of a firm such as yours going into a liquidation. What are the logistics? You've been approached by the creditor, an application's been made, you've consented, you know that the court's going to probably approve it tomorrow in the first sittings. What do you do? Is it get people together, getting things organised, knowing the size of the firm?
Not a lot you can do really until you're appointed, and we then have programs that we then follow. Once we have the appointment of the order, we're able to then freeze bank accounts, notify utilities, notify the tax office, and so forth, so that we can get word out that the company is in liquidation. We'll then try and contact the director straight away. Not much of that you can do
Until you have the authority.
until you have the authority.
Yes.
No one can talk to you.
Sure.
Until you have the authority. So.
But you've got a process, once the box has been ticked, you've got a process to go through.
Yep.
Yeah.
And contacting the director or directors, writing to them, advising them of their obligations, finding out is it trading, is it not trading. The creditor, the petitioning creditor can often tell you things like that.
Yeah.
So we'll talk to the petitioning creditor, who can then advise us what sort of business is it, what their last dealings were, what their idea has got, what's gone wrong, give us a heads up on the business itself before you then, and if it is a trading business, you turn up at the door.
And that would be the case if the trading business had a number of outlets, you'd have to facilitate to be there every...
So that pre-arranging to facilitate to be at a number of outlets, yes.
Yeah. So it can be a logistical nightmare,
Well, it
depending
can
on
be
the size.
a nightmare, but also, depending on the size of the firm, whether you have the ability to attend.
Yeah, all those ways.
And that becomes part of the...
Initial risk assessment of the business.
Yeah.
Okay? What are your risks? What is there? Are there assets that are unable to be secured? You know, is it an industry where there's health, place, work and safety issues? You know, the first day on an appointment of a liquidation is very much a risk assessment of what there is.
And you'd be working fairly closely with your legal representatives in that case with respect
Most
to...
definitely.
Yeah.
And making sure
insurance.
Yeah, it'd be fun.
Getting access, you know, not everyone's welcoming to a liquidator.
Not funny that.
Yeah. So, you know, you might have landlords not too keen to let you in, and going through all those different battles, rights of access, dealing with employees, dealing with disgruntled creditors, dealing with people who might want to take stock back. You mentioned the PPSR, you know, just keeping people calm whilst you get the lay of the land, I suppose, is a really major task.
And ensuring that when they tell you that, I know that business closed last month, we're a different business now.
Oh, yeah, the old...
You know, what authority have you got? That's when you talk to the lawyers.
The lawyers get involved. One area, obviously, of a controversial area is when we have a members' voluntary liquidation, basically where the company's come to an end or the major directors want to retire or whatever. The business is not going to be sold necessarily; it's just going to be wound down. Is that a common occurrence?
Yes, it is. There are two ways that when the company comes to, when the directors will leave, the company comes to an end. They can basically finalise everything and make an application to ASIC to have the company deregistered. Often people will want to liquidate the company to clear up any debts that may be out there that they're not aware of.
Yep.
Or claims.
To clean it all up.
To clean it up so that there's no sort of coming back at it.
Yep. So that'll be the way to do it.
Yeah, that's generally why.
Probation.
That's generally why they do a members'
Because a
voluntary.
company can be reinstated,
Yes.
but a company that's gone into liquidation
Cannot be, yeah. A deregistered company can be reinstated, yes.
Yes.
Yeah, so it's basically a real promotion.
Yeah.
Nice way of putting it, actually. Yeah.
And often that will occur if there may not be any knowledge of it, but there may be some claim, ambient claim that someone might have. They'll try and clean the company up in a members' voluntary liquidation to sort of
So
go back to rest.
it's like a probate for your will.
Yeah, so they're not waiting around for someone to come and spear them.
Yeah, right. All right, so that's insolvency, that's basically liquidations, okay? We'll see you next time when we come back and discuss receiverships, and then we'll look at voidable transactions and preferential payments. See you then.